Welcome back to company law lecture after the break due to the UTAG strike. As you know very well from the modified calendar of the university, revision is supposed to start from, let's say, tomorrow to next week. And then first, you're supposed to start exams as it were. But if you look at the Faculty of Law, how we have modified our timetable, I think that it gives you a bit more room to prepare. So I am very confident that despite the fact that we had a break, you were making good use of the time and you have been reading your company's Act 2019 Act 992 very well, especially respect to areas that we're still discussing and were yet to be discussed. So within that spirit, I welcome you happily back to discussion of directors. And we started discussion of duties of directors, and then the break came. So let us continue with what we were doing before the break, because so far we have understood who a director is, how directors are appointed, the qualifications of directors, disqualification of directors, removal of directors. We've also discussed meeting of directors, and we have also discussed special issues regarding directors, for example, resident requirements, share qualification, and so on, as the case may be. So we would like to continue with that discussion from the duties of directors. And before talking about the duties, I wish to draw your attention to what I have always been telling you, that you must have your company's acts, right? You must have your company's act readily by your side so that we can be making references and discussing them as we move along. Yeah, so first and foremost, we will have to remember that the various obligations, right, imposed on directors emanate essentially from the fact that directors are seen in law as occupying a very special position. And that position is that directors are in a sense, fiduciaries, trustees, and so on. And as we have noted already, with reference to Aberdeen Railways against the Blackley Brothers, Lord Canworth, making the point that the company, being artificial legal person, does not have a leg and hands of its own, and it has to function through instrumentality of human beings. And who are those human beings that the company function through? On day-to-day basis, it is certainly directors. Of course, we have seen the two organs, members in general meeting, and then the directors. But as we know that as far as members in general meeting is concerned, they don't act every now and again. They only act when it's absolutely necessary. So that during the what they call like the annual general meeting, or in limited situations during what we call like the extraordinary general meeting. Those are the occasions in which we see the company as functioning through the members collectively, that is the members in general meeting. Otherwise, on day-to-day basis, the company functions more through instrumentality of the directors. And that is why onerous responsibilities, as we have noted and we'll also be discussing again, are imposed upon directors. So that is what I wanted to remind you before we move on. Now, before we move on, is there any question regarding anything we'll be discussing prior to where we are? Before I move on, if you want to speak, just put up your hand and then I'll allow you to speak. Okay, so since we don't have like any question, we would continue with our discussion. So please turn with me to section 190. Section 190 of the Companies Act. And I noticed that we have a number of you here. Will anybody volunteer to be the reader for the class? So that when I want a provision to be read, you will read it and then we will analyze and discuss. Who will be reading for us? The bless, okay. The bless. Okay, the bless. Let me make you a co-host. Okay, the bless. Take section 191 for us.
Section 191. A director of a company stands in a fiduciary relationship towards the company and shall observe the utmost good faith towards the company in a transaction with or on behalf of the company. Good.
Thank you very much. Before we move on at this stage, when we say that we mentioned fiduciary relationship in law, of course, we haven't done we are doing commercial law, so you've done a law of agency, and I'm sure that that has been explained to you. Now, I would like to just quote for you from the Black's Law Dictionary what it means to be a fiduciary, and then we'll use that to explain when section 190 says that the director is a fiduciary, as it were. So from the 9th edition of the Black's Law Dictionary that I have, it explains fiduciary as follows, quote, a person who is required to act for the benefit of another person on all matters within the scope of their relationship. One who owes to another the duties of good faith, trust, confidence, and candor. The corporate officer is a fiduciary to the corporation. So that is example the Black's Law Dictionary cites. And then the meaning too. One who must exercise a high standard of care in managing another's money or property. So then it gives the fiduciary, the beneficiary sued about fiduciary for investing in speculative securities. And he will quote some earlier writers saying that fiduciary is a victim and he has been pressed into service for a number of ends. My view is that the term fiduciary is so vague that plaintiffs have been able to claim that fiduciary obligation have been breached, when in fact the particular defendant was not a fiduciary stricto sensu, but simply withheld property from plaintiff in an unconscionable manner. I mean, simply put, what we gather from fiduciary, if you wanted to go back to its Latin origin, right? The cognate or the root of that word has to do with what we call like the fidei, right? Fidei means that of faith. fidei or faith. It pertains to faith, so fidelity, so fiduciary. So someone who has been placed in charge of situation or circumstances for benefit of others, and for that matter, a higher standard of integrity or honesty is expected of that person. So that is what we should remember. So therefore, when the provision 191 says that a director of a company stands in a fiduciary relationship towards the company, it simply means that the director has in place in relation to the company to see to the affairs of the company for the benefit of the company. So the director is not acting for his own benefit. He's acting for the benefit of the company. And that is why he is required to observe utmost good faith. Utmost good faith means that he has to be very honest and open and sincere regarding affairs of the company. Right? Good. So that is the basic philosophy which serve as a context for discussing all the specific duties of the directors, that the director is a fiduciary, and being a fiduciary means that he is expected to observe good faith, and among other things, we'll be discussing that the director is supposed to act within his power. He's supposed to promote the success of the company for the benefit of members and, of course, the company itself and other constituencies. He's also expected to exercise independent judgment, because when his actions are held to accountability, it will be no defense to the director to say that I did what I did because I was instructed by someone to do that. No. So as a fiduciary, you have to exercise independent judgment, and you have to be very open, you have to be honest, you have to be candid. And of course, we'll also be talking about the fact that being a fiduciary means that he has to avoid compromising situations. Specifically, he has to avoid conflict of interest so that you don't place yourself in circumstances in which your own personal interests will conflict with the interest and well-being of the company in relation to whom you stand as a fiduciary. So these are some of the things that I think we have to keep in mind moving on. So the blessed, let's go on to subsection 2.
Section 190, subsection 2. A director shall always act in what the director believes is the best interest of the company as a whole, so as to preserve the assets, further the business, and promote the purposes for which the company was formed, in the manner that a faithful, diligent, careful, and ordinary skillful director would act in the circumstances, and in doing so shall have regard to A, the likely consequence of any decision in the long term, B, the impact of the operations of the company on the community and the environment, and C, the desirability of the company maintaining a reputation for high standards of business conduct.
Okay, so before she moves on, I think that a lot of ideas are contained in there regarding the duties of directors, and we need to unpack all of them. So let's go back to the duty of good faith, which we have mentioned earlier on, that the director has to act in the utmost good faith. We go back to that, and then we come to take the rest one after the other. So first, when we say that the director must act in the utmost good faith, what does it mean? We have explained that to start with, that obligation is there because of the character of the office of directorship. And that character is that the director is a fiduciary. Okay, so if you are fiduciary, the law says that you have to act on trust and confidence, right? And you have to act in the best interest of the company. You have to act in the best interest of the company. And as you do that, you are supposed to exhibit utmost good faith. And the emphasis is not just good faith, utmost. Utmost good faith will mean that like the highest level of what? Of good faith. That's why the utmost good faith. But good faith simplicity means acting honestly and sincerely. So that if you say that somebody has acted in good faith, that is to say that the person has acted in honesty and in sincerity, right? So that is what it means to act in good faith. And of course, the opposite of good faith is what they call the bad faith. So if you like Latin, as I do, good faith will be what do you call the bona fides, right? And then a bad faith is the mala fides. So the 992 requires directors to act with the highest standard of honesty towards the company, or when they are acting on behalf of the company. Therefore, a director will be in a breach of the duty imposed on him to act in utmost good faith if it can be shown that he did anything in bad faith. Do anything in bad faith, meaning that if he exhibited dishonest, right? It exhibited like a dishonesty, insincerity in dealings with the company or dealings on behalf of the company. And this point is not new to our act. It's a well-known company law company law principle at common law. So you go to like the old case, like the Ray Smith. You can check the chart. I hope if you're able to see what I'm writing in the chat. Ray Smith and Fawcett Limited. Ray Smith and Fawcett Limited, 1942 decision. C304. Okay. It's concerned the. Okay, I've not shown it to you. I think you should see it now. Ray Smith and Fawcett Limited against, I mean, in 1942 CH304, where the issue shared capital of a company was held 50% each. So for the two directors, each of them had 50% of the issue shares of the company. I hope you've not forgotten your shares, by the way, because the exams is just on the way. Now, one director died and his executor applied to have his shares registered in his name. The remaining director refused. The remaining director refused, but offered to register half the shares and to buy the remainder at a fixed price. The executor sought rectification of the register of members, alleging breach of fiduciary duty in refusing to register the shares of the deceased director. It was alleged that the surviving director was motivated by a collateral purpose. Collateral purpose, namely that the desire to acquire half of the deceased director's shares at an undervalue, that is at the price lower than what the shares are actually worth. The articles of association of the company provided that, quote, the directors may at any time in their absolute and uncontrolled discretion refuse to register transfer of shares. So this was a provision in the constitution or the articles of the association of the company. Now, despite such a wide power which they have been given under the articles of association, the court held that the director was still subject to fiduciary duties, which required him to exercise his powers bona fide in the interest of the company. So bona fide in the interest of the company means that good faith in the interest of what? Of the company. And the courts held further that this meant that bona fide in what the director considered and not what a court may consider is in the interest of the company and not for any collateral purpose. So yes, acting in bona fide does not mean that the court is going to second guess your judgment, but we have to make sure that what you have done does not have any collateral purpose, does not have any ulterior motive, let's put it that way so that we understand. So that was the point that the court was making in Ray Smith and Fawcett Limited. And Lord Green, who was master of the rules in that particular case, for example, made the point, and let me quote portions of his opinion for our digestion. Quote, the principles to be applied in cases where the articles of a company confer a discretion on directors with regard to acceptance or transfer of shares are, for the present purposes, free from doubt. They must exercise their discretion bona fide in what they consider and not what a court may consider is in the interest of the company and not for any collateral purpose. They must have regard to those considerations, and for those considerations only, which the articles on their true construction permit them to take into consideration. And in construing the relevant provisions in the article, it is to be borne in mind that one of the normal rights of a shareholder is the right to deal freely with his property and to transfer it to whomever he pleases. The question, therefore, simply is whether on the true construction of the particular article, the directors are limited by anything except their bona fide view as to the interest of the company. In the present case, the article is drafted in widest possible terms, and I decline to write into that clear language any limitation other than a limitation which is implicit by law, that a fiduciary power of this kind must be exercised in the interest of the company. Subject to that qualification, an article in this form appears to me to give the directors what it says, namely an absolute and uncontrolled discretion. Yeah, so you go on and on and on, but ultimately, the point Lord Green was trying to make in the Ray Smith and Fawcett Limited is that the duty to act in good faith, regardless of whatever is contained in the constitution of the company, will still stand. The duty to act in good faith is non-derogable, right? It's unimpeachable. And that is why he's saying that even if you look at the circumstances of the case in Ray Smith and Fawcett Limited, yes, there's no doubt that the Constitution gave the directors a very broad power. What was that power? That the directors may at any time in their absolute and uncontrolled discretion refuse to register transfer of shares. This is quite big a power, isn't it? But the court was making the point that notwithstanding the broad nature of the discretion given to the directors, the duty, which is an incident of a director being fiduciary, that you have to act in good faith, cannot be actually contracted out, cannot actually be whittled away by any provision in the constitution of the company. So that is, I think, the takeaway from Ray Smith and Fawcett Limited. I mean, just reinforcing the surgery provision that we have read with respect to section 190 subsection 1. And this point has been made in various authorities. We have like a plethora of authorities applying the same principle in various ways. So for example, if you look at the more recent case of J.J. Harrison Properties Limited against Harrison, right? J.J., I hope you're able to see what I write in the chat. Can you confirm, my reader, the best?
Yes, please.
Okay. Okay, so in J.J. Harrison Properties Limited against Harrison, 2002, 1 Butterworth Company Law Cases, page 162. Harrison Properties Limited owned farmland with a number of buildings and a ban on them. And the company has applied for permits to convert the ban into residential properties as part of its general policy to develop such land and sell them at a higher value. Now, before the permit was obtained, the manager, on the instruction of Mr. Harrison, who was the director of the company, caused a valuation to be obtained and proceeded to cause a contract to be prepared to acquire some land from the company at a price which reflected the fact that planning permission had been refused to develop the land. However, at the time of the acquisition, it was established that the planning permission to convert the ban into residential properties was likely to be granted, which will increase the value of the land substantially. The director, that is Mr. Harrison, was aware that the prospect of planning permission being granted and the increase in the value of the land, but did not disclose to the board at the meeting when they came to approve the transaction. Now, the court later held that the director, that is Mr. Harrison, was in breach of his fiduciary duties to the company and held the property upon trust for the company. And for that matter, he was liable to render account for the profits which he had made from the subsequent sale of the land. So he concealed the fact that the planning, the permission had been granted, and that meant that you could actually use the land for residential purpose, which was previously forbanned, and that would ultimately affect how much you could sell the land. So he kept that information to himself so that he could secretly profit from the enhanced value. And in the course of the judgment, Lord Justice Chadwick made a very beautiful dictum, which I quote. The judge went on to consider whether, in addition to the breach of statutory duties of disclosure, Mr. Harrison was in breach of his equitable duty to act bona fide in the best interest of the company. And the judge held that he was at paragraph that, quote, further, I accept that Peter Harrison was in breach of his duty to act bona fide in the best interest of Harrison Properties. It seems to me that his breach included his failure to inform the other directors of the company fully of the facts about the planning status of the development land. His failure to do what he could to ensure that if the company decided to sell the land, whether to him or to someone else, steps were taken such that it was sold at its full market value. And finally, the use of the company resources to prepare and apply for planning permission in the company's name at the time when Peter Harrison intended that he should buy the property and thus have the benefit of that work. Okay, so all these cases reinforce the point that the courts remain quite serious in holding directors to the fiduciary standard of utmost good faith in dealing with the company or in dealing on behalf of the company. Now, again, if you look at section 190, subsection 2, we have read that the director has the duty to act in the best interest of the company, right? He's supposed to act in what he believes is the best interest of the company as a whole. I mean, that is a very important obligation. So maybe let me ask you before we do that, what is your understanding when the lawmaker says that at all times the director is required to act in what he, the director, right? What he, the director, believes to be in the best interest of the company as a whole. Any thoughts? What is your understanding of that? You can just put up your hand and then I will just release you to talk. Okay, we have go ahead. Okay.
Hello, sir.
Yes.
And so please, my understanding of section 190, subsection 2, is that in as much as the law provides that the director should do what he believes is in the best interest of the company, that's notwithstanding, it will not, if that position is allowed to be interpreted literally, I believe it will, in a way, defeat the very purpose of the good faith principle and all of that. Because, and to my understanding, it is not subjective. So the director cannot say that the law allows me to do what to me appears to be my best interest. I understand that it will be objective, and the court will say that, well, it is in as much as this thing is there to say that you can act in what you believe to be in the best interest of the company, where what you do is actually not in the best interest of the company, but you believe it is, then the court will not go by your subjective understanding, but rather will resort to the objective.
Okay, absolutely. I mean, absolutely. That is quite right. Yes. Any other thoughts with respect to the import of section 190, subsection 2 in relation to the fact that a director has a duty to act in what he believes, the director believes to be in the best interest of the company? Okay, so as our friend rightly indicated that in trying to find out whether what the director did or what he did, what he believed to be in the best interest of the company, we have to use the objective test rather than the subjective test. I mean, that is absolutely true. And I would like us to look at the old case of Howard Smith. It's a case that every student of company law is aware. Howard Smith Limited against Ample Petroleum Limited, 1974. AC821. Yeah, Howard Smith Limited against Ample Petroleum Limited. It's a very old but a very interesting case, and every student who is reading company law is very much aware of that. And that is the more reason why we should also be aware of it. Now, what happened in Howard Smith Limited against Ample Petroleum Limited? Well, for our present purposes, suffices to note that in Howard Smith against Petroleum Limited, I think that my internet is not strong. In Howard Smith against Petroleum Limited, it was established that the primary purpose of an allotment of shares by the directors was to dilute and remove the blocking stake of two other shareholders who had indicated the intention of rejecting an offer by another company to acquire the company, an offer which minority shareholders and majority of the directors wish to accept. So, and within such a circumstance, the court held that the directors had not exercised their powers for a proper purpose, since the aim on the basis of the evidence was to remove the blocking stake and not to act in the best interests of the company. And similarly, in Hogg against Cramhorn, there, the directors devised a scheme and issued shares to a trust on the good faith belief that preventing a takeover bid from one Mr. B was for the benefit of the company. So the purpose of giving more shares was to empower a particular shareholder so as to do what we call like a poison pill, so as to block an imminent takeover bid. Now, in so doing, the directors sought to remain in control of the affairs of the company. And ultimately, when it was challenged in court, the court held that the power to issue shares was a fiduciary power. And if exercised for an improper motive, the issue was liable to be set aside, it being immaterial that the issue was made in bona fide belief that it was in the best interest of the company. That the issue of shares was liable to be set aside. So this reinforces the point we're making that it is the objective test which will be used to examine whether what the directors did can properly be considered as being what they believe was in the best interest of the company. So like, let's take shares, for example. Even when we're discussing shares, we know that ultimately shares, it is the directors who are in charge as whether shares should be issued or not, of course, subject to the preemption principle and all that. But where they, for example, decide to issue shares and you examine the fact and you can see that there was an ulterior motive, right? There was an improper motive to probably increase the shareholding of a particular shareholder so that he could stand in a way of eminent takeover or some other decision which the company is going to make. Then that will raise a red flag regarding propriety of what the directors did. And in that case, it will not lie in their subjective preference, but it will be examined using objective criteria, as it were. Of course, the related to this, what we call like the business judgment rule. So the business judgment rule simply comes to the fact that in making determination of whether an act done by directors was done in the best interest of the company, one must determine the reason for the judgment of the directors. And such a determination is not a subjective determination or subjective correctness of the decision, but more importantly, an objective determination based on the test of reasonableness. And the reasonable man that we know in other areas of the law is also applicable in trying to evaluate whether a director, for example, made a proper decision which can be considered as being in the best interest of the company, as it were. And still in Howard Smith against Ample Petroleum Limited, the courts are expatiated on the business judgment rule, which is also an important dimension in trying to understand what it means to say with respect to our own section 192 that a director must act in what he believes is in the best interest of the company. Now, in the Howard Smith, the court had the following to say, and I quote, "In order to assist him in deciding upon the alternative motivation contended for, the judge considered first, at some length, the objective question, whether Millers was in fact in need of capital, that is like the company. This approach was criticized before their lordship. It was argued that what mattered was not the actual financial condition of Millers, but what the majority directors bona fide considered that condition to be. Their lordship accept that such a matter as the raising of finance is one of management within the responsibility of the directors. They accept that it would be wrong for the court to substitute its opinion for that of management, or indeed to question the correctness of management decision on such a question if bona fide arrive at." In other words, the court was trying to make the point that insofar as there is no evidence of lack of good faith, right? There's no evidence of malafidis or bad faith. It is not the job of the court to second guess, right, the decisions made by directors regarding the business of the company and so on and so forth. So I think that is the takeaway. So much as the courts are interested in using the objective test, the courts are also very much aware that it's not their business to second guess or to actually challenge the business judgment of directors. The only way in which the courts may come in is where it can be shown that there was no good faith, or the fact that the directors did not exercise due care, right, in coming to a particular decision or choice, one way or the other, as it were. So let's keep that in mind. So coming back again to section 192, we notice that when directors are said to have a duty to act in what the director believes the best interest of the company, we are talking about as a whole, so as to preserve the assets, right? So as to preserve the assets, and preserving the assets means that the company should be like a going concern. The company should be like a going concern, it should be able to pay its debts and liabilities as they become due and so on. And also related to that, it also includes advancing or furthering and promoting the purpose for which the company was formed. So if you want to really, evaluate whether directors have exercised their powers or whether the director has acted in what he believes to be in the best interest of the company as a whole, it's not a very simple exercise. A lot of indices will have to be factored into the calibration that you are making. A lot of factors will have to be taken into consideration. And those factors are what 192 is telling us. So we may have to find out, can we say that the aim of exercising or making that decision was to preserve the assets of the company as a whole? Was it meant to further the business, to promote the purpose for which the company was set up? And all this are supposed to be done in a certain way. And it's supposed to be done in a manner that a faithful, diligent, careful, and ordinary skillful director will act in the circumstances. So you look at it, various standards. So we have to find out what you did. If we have like a faithful director, that is a director who acts in good faith, who acts in honesty, right? Will he have done what we did? If a director who acts in honesty or who is faithful, who acts in bona fides will not do that, then there's a question mark as to whether you have lived up to this particular duty of obligation, right? And then diligence, what you did, will a director who have exercised diligence, for example, do or come to do what you did. And they do exercise reasonable care, reasonable care and skill required of an ordinary director. So all those things are very important factors. And in living up to those standards, we also test them against a very important consideration. And those considerations are what have been adumbrated in A, B, C of subsection 2 of section 190, that you must pay attention to the likely consequences of any decision in the long term. So the decision that you have made, which you are saying that is in the best interest of the company, because of the company as a whole, because it will promote the business of the company, and so on, and that you acted with the requisite diligence, skill, and all that, you find out in the long term what are likely to be the consequences of such a decision. If in the long term, the consequences are really going to be bad for the company, then you will not have lived up to the duty imposed on you per section 192 to act in the best interest of the company, right? Or B, the impact of the operation of the company on the community and the environment. And this is another serious responsibility. So therefore, if the company was, for example, doing something and you, the directors, have made a decision, and in Ghana, or those of you who are doing environmental law, you notice that under the environmental law, there is what we call the EIA, Environmental Impact Assessment, right? You are going to do a project, for example, you don't do environmental impact assessment and then so as to know the impact of the operations on the community as well as the environment. You just go and you start, the company start running it. And then after a while, you have people suing the company that the operation of the company has caused certain health hazards to them and so on. Now, if you had done the environmental impact assessment, right, you could have known the likely impact of the operations of the company on the community as well as the environment. And because you didn't, for example, do the environmental impact assessment, you have failed in meeting the obligation imposed upon you per section 192 to act in the best interest of the company in the manner that a faithful, diligent, and careful ordinary school director will do. Because what evidence do you have to show that you actually acted in a manner which will let to gauge or be able to predict the impact of the operations of the community of the company on the community and on the environment, and see the desirability of the company maintaining a reputation for high standards of business conduct. So under our current law, corporate governance as endorsed by Ghanaian company law requires what we call like the ethical business, right? Ethical business, that is to say that where you do your business without sacrificing ethical standards. So that if, for example, your business, you support corruption, what do you mean by your business supporting corruption? Let me give you an example. Let's say that if you are in a financial institution and where others lead a big ticket investments to you, you give them a cut, right? You give them like a percentage. Or when it comes to procurement, you take kickbacks so as to award contract to certain companies and all that. All those are do not reflect high standards of business conduct. And in no time, you build notoriety for yourself in the community that, oh, as for this company, they do anything, right? That is a bad business reputation. And as a director, you are supposed to exercise your power. You are supposed to act in a manner which will show that you are interested in maintaining a good reputation for your company, especially with respect to the company following high standards of what or business conduct. Yeah, so these are very important. Let's move on. Is my reader there, the bless?
Yes, sir.
So let's move on to 3.
Section 190, subsection 3. A director of a company shall A, act in accordance with the constitution of a company, and B, only exercise powers for the purposes for which the powers are conferred.
Okay, that is another very important provision. And of course, here you see, and that is why my former teacher, for example, made a statement, and I think that he was not wrong, that there's a very close relationship between constitutional law and company law, right? And if you understand company law well, you also love constitutional law. If we love constitutional law, we love company law. If we look at this provision, for example, which has just been read, right? If we look at the 190 subsection 3, for example, that the director of a company shall act in accordance with the constitution of the company, and that only exercise powers for purpose for which the powers are conferred. So this is a reflection of our constitutionalism, isn't it? Directors have been invested with powers. They have been clothed with powers or discretion. But these powers or this discretion they've clothed with is not supposed to be in vacuum. It's supposed to be circumscribed in one way or the other. And one of the ways in which the powers are circumscribed regards the fact that they must exercise the power according to the provisions, right, of the constitution of the company. So if it has a constitution, or if it doesn't have like its own constitution, then the default constitution that we have in Act 992, that is what should guide the directors in doing the things that they do, right? So that is one. And then two, they are supposed to do what they call like the proper purpose, right? They are supposed to exercise their powers only for the purpose for which the powers are conferred. And this also reinforces what we've discussed already, that they don't have to exercise their powers for any collateral purpose, right? For any ulterior motive. So for example, I'll mention shares again. When it comes to shares, what is the purpose of issuing shares? The purpose of issuing shares is to enable the company to raise capital. Now, if directors are, for example, issuing more shares at a time when it is evidently clear that the company is not in need of, let's say, fresh capital injection, and if you look at the company and its surplus and all that is just doing very well, then you could see that the directors are not using their power to, let's say, issue shares for the purpose for which is there, which is to raise capital. They may probably be doing that so that maybe some people that they have in mind will be able to accumulate more shares and gain more power when it comes to decision making. Because remember that when it comes to polling, one share, one vote, isn't it? So the directors will have, for example, failed in exercising their powers for the purpose for which the powers are conferred. But subsection 4 provides other explanation regarding how we make a determination as to whether the directors acted in the best interest of the company. A number of constituencies must be considered. So let's take that.
Section 190, subsection 4. In considering whether a particular transaction or course of action is in the best interest of the company as a whole, a director may consider the interest of the employees as well as the members of the company, and where appointed by or as representative of a special class of members, employees or creditors, may give special but not exclusive consideration to the interest of that class.
Okay, good. So section 194 is also impregnated there with a lot of stuff. It's giving us more light. No, we have earlier on discussed under 192 that when a director is acting, he must act in what he believes in the best interest of the company as a whole, right? And that must have regard to long-term implication of the decision, must have regard to the impacts of on the community, the environment, and then must also have regard to desirability for the company to pursue higher standards of business conduct and so on. Now, there are other things. We have various constituencies in the company, right? We have like the employees, we have members, and we even have like the creditors as well, right? So when the director is acting, if we are doing, maybe if we are doing like advanced corporate law in the LLM, there's something we call like the agency cost, and you incorporate opportunism. You notice that the various constituencies, be it shareholders, that is members, be it employees, be it creditors, and even be it the directors, all these stakeholders, all these constituencies, they have their own interests. And what shareholders are interested in is different from what employees are interested in, right? Shareholders are interested in the company growing its value so that more dividends will be paid. Their investment in the company will, for example, go up. Employees are interested in the company making more money, for more bonuses to be paid, for higher remuneration to be paid, isn't it? Directors are interested in having control over the company all the time and be getting fat allowances. Creditors are interested in ensuring that the company is sufficiently liquid and is a going concern, so that as and when the company's obligation to repay credit that it has with debt that it has incurred, the company will be in a position to do that. Now, if we look at all this, you notice that the interests are somewhat divergent, pointing into different directions. So therefore, when you say that directors must act in the best interests of the company as a whole, right? As a whole, that means that directors will have to do some kind of balancing exercise in their own minds whenever they are acting or they are deciding how to reconcile and how to mediate between the apparent or seemingly divergent interests between the various stakeholders or the constituencies, which I have just mentioned. And again, we also have the very unique scenario. For example, if you remember that when we were discussing last semester, we were discussing the legal effect of constitution of the company, right? When it is registered. I'm referring you to section 20. What's the provision? Yeah, section 29, for example, effect of a company constitution. So section 29, if Blesco, for example, jump to section 29, subsection 2.
Section 29, subsection 2.
Yes.
Where the Constitution empowers a person to appoint or remove a director or any other officer of the company, that power is enforceable by that person, although that person is not a member or officer of the company.
Okay, good. So you notice that that provision contemplates the possibility of the company giving the power to some people to appoint directors, right? So where a director, for example, was selected or elected by a particular class of people. Now, question will arise. Should, just like maybe take parliament, right? If you come to constitution, national constitution, take the Parliament of Ghana, you are elected from Bosomtwi constituency, or you are elected from Adekotopon constituency or whatever, and you go to Parliament. The understanding is that you will be representing the interests of your constituency, first and foremost, isn't it? Before you even think of the bigger national interest. Is it the same for directors, where a director is elected by or selected by maybe a particular group of people? Well, that is why 194 is telling us that if you have been appointed by a special class of members or employees or wherever, it does not mean that you shouldn't pay attention to their interests. So the provision says that the director may give special, look at it, may give special, but not exclusive consideration to the interests of that class. So the law is recognizing that, yes, those who voted for you, those who selected you, right, to represent them, their interest is important. So give special consideration to their interests, but not exclusive. Not exclusive means that your deliberations, calibrations, and all the decision making that you are making should not center around only the interests of those who put you there to represent them. The law says that yes, it is legitimate for you to have them in mind. So give them a special priority, but not exclusive, meaning that you must also have regard to the other constituencies within the company or other stakeholders. And so that is what we should keep in mind. Let's move on to the next subsection, subsection 5.
Section 190, subsection 5. A director shall exercise independent judgment.
Okay, good. It is a very simple statement, but quite loaded, and it's need to be unpacked. What does it mean to say that a director has a duty to exercise independent judgment? Yes, anybody? Let's be more interactive. Yes, any thoughts? Anne, I haven't heard your voice since the resumption. And then Elsie, and then Fanuel, and Martin, and Matthew. Yes. Are you around or you are missing? Yes, any thoughts? What does it mean to say that directors should exercise independent judgment? What does it mean, and also what is the justification for that? Okay, so let's address the two aspects. What does it mean? And what is the justification for such position of the law? Any thoughts? Yes, Mr. Kojo Animedu Entry. Let me release you to tell us what you think. Kojo? Kojo Animedu Entry, are you there? Are you tired? Should I end the class? I'm happy to end if you want me to end. Okay. Matthew. Matthew. Oh, Matthew.
Yes, sir.
Yes. Yes, go ahead.
Please, my understanding of section 195 is that as part of the director's duty to act in the best interest of the company, the decision that the director or the directors take should be independent, which is to say that they should not be unduly influenced by a third party. And that third party could be a special class of people who appointed them, as we said under subsection 4.
Okay. Okay, thank you very much, Matthew. Charles. Yes, any other thoughts? Fanuel, are you there? Not there. Yes. Any other person? Nana Bediako, okay. And I go ahead.
Okay, so for the directors to act or to show independence will mean that they would act in a manner that will show that they are free from outside control, not subject to another authority. And the justification I see in that is that the directors of the company are more or less like the captains of the company ship. So the liability rests on their shoulders, and the success of the business is also at their health. So if they are allowed to subject themselves to the whims of other people or their decisions unnecessarily, then it means that the company will not be properly managed, and it will even be in breach of their fundamental responsibilities as directors as of necessity. So I think that is what the independence mean, in my opinion, and the justification for that.
Right. Thank you very much. Thank you very much. I think in relation to that, let me cite the case of Fulham, right?
Good iPad.
If you like the football, you'll be happy to hear the Fulham. Well, I'm not a football fan. A Fulham Football Club Limited against Cabra Estates. It's an interesting case. Maybe you can look at. It illustrates the point that directors are supposed to exercise independent judgment. So Fulham Football Club Limited against Cabra Estates PLC, 1994. One British Butterworth Company Law cases 363. Now in Fulham Football Club Limited against Cabra Estates, the directors of Fulham agreed with its landlord, Cabra, that it will not oppose its planning application to develop the club's ground. The directors later changed their mind about the merits of the proposed development, and they argued that they were not bound by the agreement as it fettered their discretion to exercise their fiduciary duty in the best interests of the company. Now, the agreement was binding and is not a fetter on the director's discretion if they act bona fide at the time they enter into the agreement as to how they will exercise their fiduciary duties in the future. But in the circumstances of this case, they had acted bona fide or in good faith, and the company also received substantial benefits and amounting to 11 million pounds. So I think that somebody is asking me the case. Please look at the chart. I don't know if, okay, I think it was sent to just one person. That's a mistake. I meant for everybody. So let me see. It's meant for everybody. I think it was sent to just one person. I don't know why. Oh, I don't know what is. It's only this person receiving my. Okay. As a Fulham Football Club Limited against. Okay, let me. Let me do it again. Six. Yeah, so the duty to exercise independent judgment, as Matthew and Bibiako explained, is more relevant or more engaged when you have to deal with the situation where directors were appointed by maybe a special group of people or special class of members, as it were. But ultimately, under no circumstance should a director lose his power to exercise independent judgment, because where your other duties, right, where you are being accused or being held liable for breach of your duties, it will be no defense to you that you are remote controlled or somebody else instructed you for you to act in the way that you did. So we have to pay attention to that. And that is where the Fulham Football Club Limited against Cabra becomes like interesting. So let's move on to section 6. Subsection 6.
Yeah, section 190, subsection 6. A provision, whether contained in the constitution of a company or in a contract or in a resolution of a company, shall not relieve a director from the duty to act in accordance with this section, or relieve the director from a liability incurred as a result of a breach of a provision of this section.
Okay, so section 190 subsection 6 is only reinforcing the seriousness of the duties, the fiduciary duties, right, which are imposed upon the director to act in utmost good faith, to act in the best interest of the company as a whole, and so on, to exercise independent judgment, to exercise powers only for purpose for which the powers are conferred, right? And at all times, those obligations or those duties are meant to be kept, and they cannot be contracted out, right? They cannot be contracted out, and the company can also not put a clause in this constitution saying that directors are excused from those fiduciary obligations that we'll be discussing. Yeah. So let's move on to, okay, we will end here, and then tomorrow you'll continue. So have a very good night. I've seen some hands up. Okay. Mr. Animedu, the hand is up. Let me hear you. Ojo, the hand is up.
Yeah, sir. Good evening.
Good evening.
I just wanted to find out whether tomorrow's class will be online or in person.
Yeah, Ezekiel will come to do the tutorial. That will be in person. But apart
Okay, sir.
yeah, so apart from the tutorial, I'll have another class like this, okay?
Okay.
Then
Thank you.
all right, thank you. Nana Bediako.